3, 2, 1.
Good evening. We will call to order the February 10th meeting of the Brisbane Planning Commission. This virtual meeting is compliant with the Ralph M. Brown Act as amended by California Assembly Bill number 361, effective September 16th, 2021, providing for a public health emergency exception to the standard teleconference rules required by the Brown Act. The purpose of this is to provide a safe environment for the public, staff, and planning commissioners while allowing for public participation. The Planning Commission meeting is being broadcast on Comcast Channel 27 and the city's YouTube channel at youtube.com/BrisbaneCA. The agenda materials may be viewed online at brisbaneca.org/meetings. All written comments submitted before 2 p.m. of the day of the meeting have already been provided to the Commission and available for public inspection at the front lobby in City Hall and online at brisbaneca.org/meetings. Any writings received after the agenda has been posted, but after 2 p.m. of the day of the meeting will be available online at the start of the meeting at brisbaneca.org/meetings, at which time the materials will be distributed to the Commission. For those who did not provide written comments, a call-in telephone number was provided on the agenda, which can be viewed online at brisbaneca.org/meetings. The phone number and instructions will also be provided during the meeting. Participants in the Zoom webinar may make their comments through Zoom. Please note that Zoom participants will only be able to access the Commission verbally. I will announce time limits for public comment during a particular item as needed. Staff, may we have a roll call, please?
Commissioner Funka?
Here.
Commissioner Gomez?
Here.
Commissioner Gooding?
Here.
Commissioner Patel?
Here.
Commissioner Saison?
Here.
Thank you. May we have a motion, please, to adopt the agenda?
I'll make a motion.
Any seconds?
Second.
Roll call, please. Or voice vote, please.
Commissioner Funka?
Aye.
Commissioner Gomez?
Aye.
Commissioner Gooding?
Aye.
Commissioner Patel? Commissioner Patel, I'm sorry.
Aye. Yes.
Commissioner Saison?
Aye.
All right, the agenda is adopted. Are there any members of the public or any commissioners who would like to pull any item from the consent calendar? And staff, please post a text and call number on the screen. Any Zoom participants who want to pull any item from the consent calendar can raise their hand by pressing the raise hand button or by pressing *9 on their phone if they have called in. So we're running a 30-second timer. Meanwhile, are there any commissioners who would like to remove any item from the consent calendar? Hearing none.
Ten seconds. Okay, 30 seconds has elapsed and no one raised their hands.
Great, thank you. Are there any oral comments from the public on any items not on the agenda?
Through the chair, did we adopt the consent calendar?
Oh.
Or approve it?
Sorry, thank you. I have a motion, please, to adopt the consent calendar.
I'll make a motion.
Any second?
Second. I second.
Voice vote, please.
Commissioner Funka?
Aye.
Commissioner Gomez?
Aye.
Commissioner Gooding?
Aye.
Commissioner Patel?
Aye.
Commissioner Saison?
Aye.
All right. Consent calendar is adopted as presented. All right, any oral comments on items not on the agenda can be called in by calling our teleconference number in the next 1 minute or made by participants in the Zoom webinar. Staff will display the call-in number on the screen. Any Zoom meeting participants should raise their hand to indicate to staff that they would like to address the Commission on any items not on the agenda. Callers must press *9 to raise their hand. And we're running a timer for 1 minute. While that is running, I don't believe that we have received any written items of correspondence or communications. Am I correct?
That's correct.
Okay, thank you. So we'll just wait for the minute timer to run.
Thirty seconds. Ten-second warning. All right, 60 seconds has elapsed and no one has raised their hand or called in.
Thank you. Move on to the new business. And the first item of new business is regarding 260 Annis Road. And that is short-term rental permit 2021-STR-1, an appeal of a decision by the zoning administrator regarding this short-term rental application. Staff, may we have your presentation, please?
All right, thank you, Chair. As introduced, this item is an appeal of the zoning administrator's denial of short-term residential rental permit 2021-STR-1. I'll give a brief synopsis of the staff report before moving on to questions. The City of Brisbane adopted an ordinance that took effect in summer 2020, which permitted short-term rentals, or STRs, subject to a number of operational and performance standards. Generally, STRs may only occur within single-family dwelling units. Hosts must own the dwelling and permanently reside within it. No host shall conduct STR activity within the City of Brisbane without an approved STR permit issued by the city, and unhosted stays are prohibited. Since early 2021, the city has been in contract with a vendor called Host Compliance to automate the STR permit process and monitor STR activity across multiple listing sites, allowing the city to initiate code enforcement as needed and pursue the collection of transient occupancy tax, TOT. On July 1st, 2021, a non-compliance warning letter and TOT delinquency notice was delivered to the owners of 260 Annis, requesting payment of past TOTs within 30 days and the removal of all active and non-compliant STR listings within 10 days. It also indicated they should apply for an STR permit if they wish to continue operating as an STR. The owners of 260 Annis submitted their application on July 16th, 2021, and it was not deemed complete until October 21, 2021. Per Brisbane Municipal Code Section 17.35.030, staff performed an on-site inspection to verify the dwelling unit complied with life safety standards and ensure the application met all STR operating standards and requirements of Brisbane Municipal Code Chapter 17.35 as certified by the applicant in their application. Staff identified the following discrepancies with the information provided by the owners on their application and the conditions observed on the premises. First, the applicant submitted plans indicated a maximum of 2 rooms would be rented on either the upper or lower floor, while the owner would occupy the floor that is not being rented. During the inspection, staff observed the upper floor was occupied by short-term renters and that the lower floor of the home was occupied by a renter, identified by the owner's representative as a long-term renter. Renters on both floors would mean the property owners were not occupying the property in violation of Brisbane Municipal Code Section 17.35.040.a and contradicts the information provided by the owners on their application. Second, with long and short-term renters, the question of owner occupancy becomes an issue. So staff investigated past rental listings and the insurance coverage more closely after the inspection. Staff learned multiple listings were posted to a number of sites, including multiple and separate listings for an upstairs unit and a downstairs unit with a separate entry across a number of different listing sites. Every listing also specifically advertised Marbella Lane, a vacation rentals investment and management company is managing the home. Furthermore, the insurance policy identifies the occupancy of the home as, quote, vacation and short term, and is underwritten by a firm that specializes in policies for businesses and commercial properties. This policy type and coverage contradicts what a local farmer's insurance agent informed staff of, which is that owner-occupied homes that offer short-term rentals may be covered under a regular homeowner's policy with an endorsement for STRs. Third, plans submitted with the application identified 2 covered off-street parking spaces within the garage, but the on-site inspection revealed both parking spaces were obstructed and unavailable for short-term renters in violation of Brisbane Municipal Code section 17.35.040.I. Following staff on-site inspection and review of the application materials, the zoning administrator denied the permit on January 6, 2022, finding that the applicant does not meet the definition of a host as defined under Brisbane Municipal Code section 17.35.020.b, and the dwelling to be offered for short-term rental at 260 Annis was found to be in violation of short-term rental operational standards for on-site parking and hosted stays pursuant to Brisbane Municipal Code chapter 17.35. The owners of 260 Annis filed a timely appeal on the grounds that they are the legal owners and legal owners of records and occupy the dwelling unit, and therefore would qualify as a host under the code. Their appeal also stated that, contrary to the statement made by the representative at the site inspection, there is no long-term renter on the premises, and the items stored in the garage have been removed to comply with operational standards for on-site parking under the code. Following the filing of their appeal, staff became aware through host compliance that the property continued to be used for short-term rentals, specifically within the month of January 2022, notwithstanding that the owners have not received a permit to do so, and issued a citation on February 2nd, 2022. Per Brisbane Municipal Code section 17.35.030, where there has been an administrative citation issued for an STR violation within 12 months, no short-term rental permit shall be issued. Based on the application materials submitted and the observed site conditions at the premises, staff's conclusions and analysis presented to the zoning administrator to recommend denial of the application are unchanged by the applicant's appeal materials. Of particular note, the applicant's claim that the lower level was occupied by a short-term renter rather than a long-term renter still constitutes a violation of the STR operational standards and provisions, since the upper floor was also observed to be occupied by short-term renters. If both levels of the home are rented out with no owner occupancy or hosting, the following STR operational standards would be violated. 1, unhosted stays are prohibited. 2, limitation on bookings, meaning individual rooms within an STR shall not be booked to separate unrelated rental parties. And 3, no more than 2 habitable rooms may be rented at any given time during a stay. Staff recommends the commission deny the application and appeal due to the following facts. First, the applicant does not meet the definition of a host as defined under Brisbane Municipal Code section 17.35.020b, in that the applicant has not adequately demonstrated they reside at the single-family dwelling unit for at least 275 days out of a given consecutive 12-month period. Second, the single-family dwelling to be offered for short-term rental at 260 Annis has been found to be in violation of operational standards applicable to all STRs under Brisbane Municipal Code section 17.35.040, specifically that unhosted stays are prohibited. And finally, under Brisbane Municipal Code section 17.35.030d, no permit for an STR shall be issued if within 12 months there has been an administrative citation issued for an STR ordinance violation. The city issued such an administrative citation to the owners on February 2nd, 2022. This concludes staff's presentation, and I welcome any questions from the commission at this time. I also want to highlight that Michael Roush, the city's legal counsel, is present and can answer specific legal questions.
Thank you, Jeremiah, very much. All right, commissioners, any questions of the staff on the presentation? Commissioner Funka, any questions?
No, it seemed very thorough. I think the only, like a rebuttal is the only thing I could imagine, because it sounded sort of irrevocable to me, the grounds for denial.
Thank you. Commissioner Gomez, any questions of staff regarding the presentation?
No, not at this time.
Thank you. Commissioner Patel, any questions of staff?
No, I just want to commend Jeremiah for doing an excellent job. Thank you.
Commissioner Sayasan, any questions of staff?
No, again, very thorough, Jeremiah. Thank you.
Yeah, I agree. I commend the staff for having really done a lot of homework on this and tried to drill down pretty deep. I wanted to clarify one thing and make sure I understood it correctly. I think in the exhibits, the way I interpret it, there was evidence that as recently as January of 2022, the applicant was still advertising the property as rentable as a short term for the entirety of the parcel. That is the entire 2,000 square feet. Is that correct?
There was a listing for it. I'm not sure if they were able to change it to 30 days. We do have 2 documented stays in the month of January, though, for our host compliance vendor.
And were they for the entirety of the unit or for one portion or the other?
I can't speak if it was for the entirety of the unit or one portion. I believe their most recent active listing was just for the upper floor.
Because looking at the, if I can get quickly enough to the packet that you sent out. There appears to be a listing. This is as part of attachment F. That appears to have been culled from one of the websites on January 23rd, 2022. It appears to be for 2,000 square feet, which to my understanding is both the top floor of 1,200 square feet and the bottom floor of 800 square feet.
You have to know which listing that was. Was it a booking.com listing or?
Yes, exactly.
And it's page 35, page 35 of the materials.
And it's listed as a 3-bedroom penthouse executive suite. I just note that for the record because I think that is evidence that the entirety of the structure is being offered for rental, as opposed to any portion thereof. Okay, anyway, that's just sort of my comment, perhaps more than a question. Let's see, are there any other questions or comments by the commission at all at this point? We'll have discussion after the public hearing, but any other questions? No? All right, in that case, we'll open the public hearing and we will ask, is the applicant present?
Yes, I will be promoting them right now. I believe Peter is going to be speaking on behalf of the applicants. Peter, you should be able to turn on your video and unmute yourself. You are still muted, Peter.
Hello, everyone.
We can hear you now.
Should I proceed?
Yes, go ahead.
Okay.
Thank you.
Hello, everyone. Thank you for the opportunity for my clients to file the appeal. Our position is that the insurance, the garage, a couple of those items that were of concern have been dealt with. I requested that my clients cease any and all listings as of January 24th when I sent the letter to Brisbane. So my understanding is that when all the materials were done and the actual appeal was submitted, from that point forward, there were no further listings. I do realize that there were 2 unpermitted listings or short-term rentals that did take place. And so I would like my clients to address that. But in terms of all of the other requirements, it seems everything else has been met. Yan and Sunnen does live and reside. She's one of the title owners along with her husband, Willie Chang, and she does reside in the bottom unit or the downstairs, not unit, the downstairs area of the place. I think the only issue that I see from my perspective is that those 2 violations or alleged violations, which I would like my clients to address. I will say that this was all before I submitted the appeal and instructed them how to proceed, and so I don't think there was any bad faith on their part. I don't know if discretion lies with the commission to allow them to move forward based on those 2 violations, but I'd like them to address that if they can. Yanin, can you explain those 2 short-term rentals that did appear in terms of the commission's records?
Oh, yes. So those are the bookings came in a long time ago. They are here for vacations. We just, want to host them and then finish them. But we understand it's against the policy. and then we will pay the citation, and then we will follow all the policy from the city of Brisbane.
Do you recall, may I ask you, do you recall when those bookings were made? The ones that were the 2 in January that the commission is referring to?
I don't remember exact time. I need to look into it.
Roughly, yeah.
Probably last year.
The only reason I bring this up, and I'm not sure if there's discretion here, but you know, there might have been a breach of contract or some other repercussions for my clients at that point. But clearly, I told them to stop any and all listings, and I believe the record will show that the listings did stop on either January 23rd or 24th when I instructed them to remove all listings. And I think since that time they were stopped. The garage was emptied, which was required by the commission. The insurance is a homeowner's policy that includes vacation rental. And so it's not, I wouldn't call it a commercial policy. It is a homeowner's rental policy, homeowner's premises liability policy that includes short-term vacation rental. And I submitted that declarations page to the council or to the commission. So I think if there was discretion, I would say that in terms of their good faith behavior and trying to comply with everything but those 2 short-term rentals that happened before January 24th, that would be the only issue.
Okay, thank you.
And we're happy to answer any other questions, obviously, of the commission. And at this point, we're not talking about a long-term rental situation. Obviously, the statutes limit the amount of rentals per year, but we're hoping that the commission would enable them to continue in compliance as required.
All right, let me ask the commissioners if they have any questions of the applicant. Commissioner Funke, do you have any questions?
I was wondering if you could address the residency part of it. That seems like an important part of the code. And is this a case? I don't know how you establish the facts. Was the required minimum, I think, 275 days out of the year, was that met or not?
Yannin, can you explain to the commission who lives downstairs and how, if you have any other residents, or what the situation is with your residents there?
Yes, so I'm living downstairs with my sisters and then my sister's husband and their kids. So we don't have a long-term tenants on the property period. I was not here on the day when the inspectors are here. And then I didn't know what they told my helper was here just showing the house. I didn't know what she said, and she doesn't even speak perfect English. I believe there's miscommunication, misunderstanding, but we don't have a long-term tenants here. And just to add it on, earlier the question says there's 2,000 square feet house marketing on booking.com. It is part of the house. The house is huge. It's almost 4,000 square feet. So upstairs and downstairs. So 2,000 square feet. It is just one part upstairs of the house. When we rent it out as part of the house.
That's an important distinction I'd just like to draw, is that I believe earlier the intimation or inference was that the 2,000 plus square feet was the entire place, which meant that the entire place was being rented out, but that's not the case. It was listed as 2,000 feet, which encompasses the top floor.
Yeah, you might got confused. It's saying the entire place. We did consult with the one of the city staff before whether we can advertise that way, because downstairs we do have a separate entry. That's why we be able to advertising as a whole place, although it's part of the space. But in the description of the listing, we clearly explain to the guest, okay, you can only access to the upstairs, and then it is, upstairs space, and there are other residents living downstairs.
So I just have a follow-up question.
Sure.
So why did you put as evidenced in attachment F, item B, that at Maribel Lane is advertising a 3-bedroom penthouse executive suite SFO on Annis Road. And when I look up 260 Annis Road, it's a 3-bedroom. So
Well,
how are you saying, I'm sorry, I'm not done yet. Why are
Okay.
you advertising for 3 bedrooms when you're not actually renting out the entire place, when that's the total number of bedrooms in your residence?
Oh, well, we actually only advertising 2 bedrooms. I don't understand why there's 3 beds come from. We can pull out the listing from our side. It's only 2 bedrooms has been rented out.
Well, I'm looking at what staff has provided on page 35 of 105. It says 3-bedroom penthouse.
Where is that listed, sir? Because I haven't seen that attachment. I don't know what you're.
That's in booking. That's in booking.com.
And is there a date from that listing? When that listing was made?
I believe it's around January 23rd, 2022.
Are you familiar with the January 23rd bookings.com listing that indicates 3 bedrooms? And how many bedrooms are upstairs, Yannin? There's only 2?
No, 3, there's more common space, but here's the thing, we only advertising 2 bedrooms, and then it is one website, and then use a software push out to all other sites. Sometimes all other sites, they don't coordinate the information correctly, but we definitely didn't advertising 3 bedroom of all the websites. That's not what our intention to do. We know, we actually studied the policy with one of the staff, and then we understand that only 2 bedrooms are allowed to booked. And then I don't have with me, but I'd be able to provide those record of we only been rented out 2 bedroom. And I'm very clear, but I'm very positive about it because we did study and discuss this with the city staff. Okay, what is the right way to do? That's, we've been advertising 2 bedrooms.
If I can ask a question for clarification, please. How many bedrooms are there total in this entire structure? 3?
3.
Okay, 2 upstairs and 1 downstairs?
Well, there's one big space considered bedroom downstairs, and there's 4 bedrooms, like 3 separate rooms and 1 more bigger rooms upstairs. So
it seems to indicate that there's actually more than 2 bedrooms upstairs. There's 4 big rooms, 3 of which may be considered bedrooms. So it may not be in conflict.
What I know, what I believe is on that day when the inspector show up, they never went downstairs because they would never. My helper told me is they will come back to the second time to check the downstairs, but they didn't even see the downstairs. They only saw the upstairs space.
Through the chair, their submitted application shows 3 bedrooms on the upper floor, and during the site visit, there were 3 bedrooms on the upper floor. We did not see the downstairs. Their site plan shows a bathroom and kind of a living area downstairs, but again, we didn't see the downstairs because the representative, which is your sister, correct, said there was a long-term renter and we weren't able to go down there.
Yeah, and I apologize, that's not correct information. We don't have long-term renters here.
I have a question on different matter here. So Ms. Sun, you were given notice of non-compliance in July 1 of last year, and a couple of weeks later, you then started the application process. So my question is, why, when you're trying to apply for a permit, did you continue to get short-term renters to come on the property?
Yeah, last year, yes, we were doing that.
So yeah, so that's my question. So if you're in the process of trying to get a permit and to become legal, why would you continue to engage in activity that was not permitted?
Can I just say one thing, and I'll let her answer as well, but let me just say this, is that I've had a number of sort of Airbnb people come to me. It's not my primary area of practice, but I've had a number of different jurisdictions where I've helped people where they don't know exactly what they're doing. And that's not to excuse their behavior, but oftentimes they realize that there is far more involved regulations and necessary compliance things that they have to go through. So I believe there was a bit of that because different jurisdictions also have different requirements, and they can vary extremely. And so that's not to excuse her behavior, but I think what I appreciate the commission to look at is that she is trying to comply. She completely emptied out her garage. She completely provided all of the information requested by the commission, and she's of course going to pay the fine, obviously, and be committed and welcomes future inspections to ensure that compliance. Yanin, do you want to add something to that?
Oh, I agree. Everything you said. We just didn't know what's going on, and then, we actually try to make the process as fast as possible to apply the permit. But there is probably more than, at least like what I know is like 4 or 5 people touched our application. So every time we talk to different people, there's a new requirement, and it's always changing things. So and then it's dragging so long for half a year time. So obviously we want to get our permit going as soon as possible, but it didn't happen.
This is
Sorry,
really, I would attest for that. There was multiple change of hand at City of Brisbane was very confusing.
But my also concern is that once there was the inspection and you were informed further of violations, that you continue to post on these sites for short-term renters and had people renting the property afterwards. So that's my problem with good faith, is that there's this constant violation of the code, knowing violations. And even if we were to have discretion, the statute doesn't allow us discretion to, you've admitted to the violations, that's a fact. So based upon that, what the zoning administrator decided, he was well within his rights to do so based upon the facts. And, if we had discretion, I would find it very difficult to exercise it given these willful violations. But regardless, there is none. The commission's hand is pretty tied based upon the law.
Commissioner, are you referring to the 2 violations within a year? Is that the specific law that you're referring to?
The violations after you were denied the permit.
Well, that a permit cannot be granted if there are 2 violations within 12 months. I think is that the one? I believe that's what the regulation states. No?
Yeah. I believe it was any violation of the code, meaning that I think from the first violation before you even started the application process, I think staff could have denied it based upon that violation of the law. Am I correct, staff?
So the code section is if there is an active code enforcement case or a administrative citation issued within the last 12 months, you cannot be granted a short-term rental permit.
Okay, so it was after that.
I have not reviewed the statute. I would welcome legal counsel's opinion on that. I don't know if there's discretion or not. I would accept your perspective on that, but usually there is some discretion in these cases. And obviously there was a lot of understanding and learning process going on here. And I would argue that, based on our last month of trying to comply with everything and providing all this information to the commission, if there is discretion, that it be allowed. But counsel, please.
So let me get us back on process here.
Sorry.
Oh, that's all right. You're part of the process.
Okay.
I just want to make sure that other commissioners have had a chance to weigh in with any questions of the applicant, if there are any more. Commissioner Patel or Gomez, any other questions?
I have a question for the applicant. The applicant indicated that there was an error in posting the fact that it was the entire space, but in other postings, she does post only a 1-bedroom. So how is it that you made the distinction between posting the entire place and then only posting on certain other dates just the 1-bedroom?
I think there's a lot confusing here on the listings. So before we got a letter, I believe it's July last year, from the city of Brisbane states we need to get a permit, and then this is what is, you're only allowed to advertise in 2 bedrooms, and then we've been following that policy. But before that, when there's no policy in Brisbane, we were advertising 1 bedroom sometimes, 3 bedroom sometimes, it depending, you know, when like upstairs can get bookings or downstairs booking, then we switch. But that was before we get up, you know, getting the letter from city saying you have to get a application. But after the letter, we've been working with the city staff to learn, okay, exactly what we can post. So after that, the post is consistent. There's no 1 bedroom listing after that. So I don't know what you are looking at, but it was not a recent listing.
It was a listing from August 2021.
I believe so we don't have that. The list was shut down. We don't have that listing. I mean, on
January of 2023, 2022, you list the penthouse on the top floor with the separate entry, completely separate unit downstairs on the second floor. When you wrote that in your listing, were you saying that you were actually living in the second floor where you were asking people to rent that out for short-term rentals?
No, we are living there. We don't have more space to rent it out, only upstairs.
So then you basically were offering up a piece of property for short-term rental that was a lie, right? Because you're saying you're offering the penthouse on the top floor with the separate entry, completely separate unit downstairs on the second floor.
No, that's not what I'm
Can I
offering.
clarify something? Hold on. My understanding, and I may not be correct, is that there's downstairs, there's upstairs, and then there's a penthouse situation on the roof. Is that not correct? Or...
No, the penthouse is the upstairs.
Okay. So what was your question, sir, Mr. Patel? I'm sorry, I didn't. Can you repeat it, please?
The listing from January 23rd, 2022 says penthouse on the top floor with a separate entry, completely separate unit on the downstairs on the second floor. That's what's being offered up for rental on the January 23rd, 2022.
What do you mean by a offered for rental?
2022 listing.
It might be a grammar situation because it doesn't make sense to say downstairs on the second floor. Is that what you're reading, sir? I don't have it in front of me.
Completely separate unit downstairs on the second floor.
Well, downstairs on the second floor, that statement doesn't make sense because downstairs is not the second floor. Downstairs is the first floor, no?
So all we try to do is we try to tell the people who are looking at our listing, we are renting out part of the house upstairs. We call it penthouse, and we're explaining to them, expecting people, resident to live downstairs. They cannot expecting an entire house. So that's all we try to do. We are not renting out downstairs after we've been approached by the city. You need to get a permit to do this.
Okay, I have a question as well, Ms. Sun. Marbella Lane that manages this property is a company owned by your family, correct?
That's correct.
And is it the business of Marbella Lane to own and operate not just this one, but other properties for vacation and short-term rentals?
That's correct.
And for how long has your family been running Marbella Lane? Approximately.
Probably 3 years now.
So this is not the only structure that your company operates as short-term and vacation rentals, correct?
Are you referring to the city of Brisbane, Mr. Gooding? Because
anywhere.
Well, there's different regulations in other jurisdictions.
Of course, I understand
that.
Yeah. I'm going to, the family's experience generally with needing to be cognizant of short-term rental rules and regulations. And this is not the only property you folks run as a short-term rental or vacation rental, correct?
Correct. We manage more properties on homeowners' behalf. Yes.
Okay, thank you. And then as part of what you do as Marbella Lane is to participate in creating listings on various different platforms like Vacasa and Airbnb and all those ones, right?
That's correct. We do that with software. Yes.
That's part of your business, is figuring out how to manage those listings, right?
That's correct.
Okay. All right. Any other questions from commissioners at all?
Well, Doug, just to clarify, Maribel Lane, it's its own website as well that
Yes.
posts. Yeah.
Thank you. Yeah. All righty. Is it time, I believe, to have a motion to close the public hearing?
I just wanted to return to my question to council, whether he felt that there was discretion. I don't know if now's the right time in terms of procedure, but in terms of whether there's discretion underneath that statute mentioned, whether there can be any violations within 12 months if there is a permit application. In other words, that a permit must be denied. Is that non-discretionary if there is a permit violation?
Chair, want me to respond to that?
Sure, go ahead, because we'll probably ask you if he doesn't.
Sure. Thanks. Michael Roush, legal counsel for the city of Brisbane. The way the ordinance, this particular section reads is that no permit for a short-term rental shall be issued if within 12 months there has been an administrative citation issued for a short-term rental ordinance violation. The way that I look at that is that if there had been an administrative action undertaken or a citation issued and it was being contested, so in other words, it hadn't been proven, for example, that there had been a violation, then I think the commission would have the discretion to say, until that issue, if that were the sole grounds that the commission was looking at to deny the permit, I would say the commission should wait until the conclusion of that process to determine whether or not there had been a violation. In other words, it would not be fair to an applicant to assume that the violation had occurred just because a citation had been issued. So if that were the sole grounds, I would say that we would have to wait for that process to play out before I would say the commission really had no discretion but to deny the permit. This particular case, from what I'm understanding, and I don't know this is going to play itself out, the applicants, the persons who have been given a citation, are not going to contest the citation. But that time has not completely lapsed at this point, so I can't say conclusively that that's going to occur. But based on their statements that they're not going to contest it, then the citation essentially has been upheld, and the commission really doesn't have any discretion but to deny the permit. But sort of unfortunately, we're sort of in that limbo period because the appeal period or the time to appeal the citation has not run. Accordingly, I would suggest the commission focus on the other grounds, for example, the grounds that the zone administrator came up with to deny the permit initially or in the first round, and focus on that as your grounds to either approve or deny this permit. Just because of the way things stand with the citation, that would be my best advice to you so that you don't run astray.
Okay.
Thank you.
So the way I interpret that, if I just add one sentence, is that at this point, it's not, they have not technically submitted that form that they just received, or it's not come to the statutory petition because of time. And so that, for the moment, cannot be used as a reason at this time.
I would say that if the commission wanted to use that as a grounds, that it could do so, but subject to the citation being upheld at some point if it were appealed.
Thank you.
And Mr. Roush, when does the, educate me, when does the appeal, well, when does the window close on appeal of the citation?
The citation was issued on February 2nd. It's a 10-day appeal period, which would be February 12th. Because that's on a Saturday, they would have until February 14th to file a timely appeal.
All right, thank you very much.
I guess what I would say, just in conclusion, without being too, dominating here too much, is just that if the commission feels that there's largely compliance moving forward, realizing that in the past there's been a lot of missteps and mishaps, which clearly has been the case, but if there's largely compliance moving forward, and since January 24th, then it appears that as of today, there could be the possibility of accepting the permit or reversing the decision, and leaving it at that. And that's all I would say at this point. Thank you for listening.
Thank you. All right. Next, may I have a motion to close the public hearing at this time?
Through the chair, we actually never posted the call-in number. Do you want to give a little time for that?
Sure, let's do that.
So we'll have it up for 120 seconds, or that's our usual time for public hearings.
We'll just drum our fingers until then.
Halfway there.
Okay.
Through the chair, I
Yeah.
have a text question that came in during the comment period. Question being, how many days were they residents? I presume this means the testimony from the appellant that they're currently residing. And Jeremiah, I believe there's some code standard for how many days out of the year they need to reside to qualify.
Yes, I believe it's 275 days out of any 12-month period.
So, Ms. Sun, do you have any records that would document your residence at that location during the past year?
Of course, any document you would, I have ID here, the tax here.
You have utility bills indicating
Yeah,
your
we
name
have-
on that address?
Yes, we have everything. We own another property in Pacifica that's do short-term rental, but it's, fully combined with the city. We, as a whole house, this is the only place we have for in the area. We have to stay here. And then, the majority of my business is here. I don't have other place to go.
All the primary documents are all on this address and we live here.
Yeah, I mean, any document you would ask for as evidence, we would provide that.
Bank statement, legal IDs, all to Annis, and we live here.
Oftentimes, sometimes you could look at whether or not the person is registered to vote at a particular location. Whether, that sometimes is evidence of residency. driver's license is, at that location. Those are the kinds of things that typically one can look at to determine whether or not a person is a resident at a particular address. I don't know whether these particular owners are registered to vote, or if they're at this location, or if their driver's license shows this particular location as opposed to somewhere else. Again, not determinative, but usually good evidence.
We're happy to send anything to the commission next week, by early next week, if need be, any utility statements, bank statements, copies of IDs, whatever.
Yeah, I like to add, that was first submitted on the initial application, but we can resubmit those. In the first application, initially, these has to be vetted. It has been vetted, but we can resubmit it.
Okay, has the time run for any other public comments?
Yes, it has. And no one has called in or raised their hand.
Thank you. All right, our discussion time is open for deliberations. Any further comments or deliberations or thoughts?
Through the chair, we need to close the public hearing.
Thank you. I may have a motion to close the public hearing, please.
I'll make the motion.
Any second?
Second.
Voice vote, please.
Commissioner Funka,
Aye.
Commissioner Gomez,
Aye.
Commissioner Gooding,
Aye.
Commissioner Patel,
Aye.
Commissioner Saison.
Aye.
All right, public hearing is closed. Now deliberations. Any thoughts or comments by the commissioners? We'll go alphabetically. Commissioner Funka.
I am wondering, the denial, is that effective forever? Or does it elapse? Like we deny it now, but they can reapply in a year?
So my understanding, Mr. Roush, is that one basis for denial at this time would be because of the citation issue, which, as you have suggested, may not be fully ripened yet.
Correct.
The other issue, the other potential bases for denial, I'm not sure about any sort of length of sentence.
And the other one is if there were unhosted stays on the property.
Correct. The whole operational standards that Mr. Robbins has set forth in his agenda report, as well as verbally tonight, certainly provide ample grounds to sustain the denial because of the unhosted stays following the letter that was sent out in July of 2021. Certainly provide the grounds to do that if the commission so desires. To go to the other question, the general rule is, and I'm not sure if the Brisbane Municipal Code has this provision, but the general rule is that there needs to be a year's waiting period between the time of a denial and when another application can be submitted. That's the general rule in most cities. I don't know if Brisbane follows that, but I would assume that it does.
I see. Okay, thank you. That's.
So Mr. Roush, so I have a follow-up question. So if we find the facts that there were unhosted stays on this property, are you saying we still have discretion to grant the permit?
I would say that you have to look at the totality of the circumstances. And if you feel that notwithstanding that there were unhosted stays and other violations, there were no citations issued for those. And if you conclude that based on the evidence that you've heard from the applicant and the applicant's attorney, that they intend to, at least on a going forward basis, comply in all respects with the ordinance, then I do think you have that discretion. The same way that I think you have discretion to say, based on your history, after July of 2021, we're not convinced that that you have shown the requisite good faith for us to issue you or to overcome the zoning administrator's decision. So I think, you have a great deal of discretion in this issue, taking into account all the testimony that you've heard tonight.
I have one more question, perhaps jumping in ahead of the other commissioners, if you'll excuse me. Mr. Roush, if they were to contest the existing citation of February, whenever it was.
Third, second.
What is the next forum for that citation?
What would happen is that there would be an administrative hearing officer appointed, and there would be a, kind of like a mini trial in which the city would try to prove its case to the administrative hearing officer as to whether or not there had been a violation of the ordinance. If the administrative hearing officer concluded that that there was a violation, then essentially the citation is upheld. If the hearing officer concluded otherwise, then the citation certainly would not be upheld.
Okay. Thank you. All right, Commissioner Gomez, any deliberations, opinions, thoughts?
I commend Commissioner Patel. I had some similar lines of inquiry, and he beat me to it. For me, the fact pattern is rather suspicious. And I think we've had good deliberations thus far, but I don't have any other color commentary to add at this point.
Okay, thank you. Let's see, Commissioner Patel, any further deliberations or thoughts?
I would just like to, just because if this is a record, then I'd like there to be on the record the fact, well, I guess Planner Robbins' attachments are all going to be part of the record. But when we look at page 26 of 105, there is nothing in this particular document, which is the farmer's insurance policy, that indicates that this is any type of homeowner's insurance policy. It really does cover, it really talks about vacation and short-term rentals. It talks about reduction in coverage when vacant and unoccupied, dwelling fire of a landlord. There's nothing in here that indicates that either of the applicants who were actually living in this policy. In fact, there's a tenant screening discount as part of this policy, all indicating that this is a commercial property.
I asked something.
It's not open comments right now, so it's not your turn. When we look through all of the other documents that have been submitted and put things into context, these applicants indicate that they own a business for short-term rentals. They've created their own website for short-term rentals. This website lists numerous properties, and then they list these on separate other websites such as booking.com. They are experts in listing these properties based on their own testimony that they started this business and do this in many different locations. When they listed on January 23rd, 2022, their listing, they say penthouse on top floor with separate entry, completely separate unit downstairs on the second floor. They are offering up for short-term rental their entire property. I see you shaking your head, and I disagree with your shaking your head, because on a different posting, specifically when you look further down in the document provided that were obtained by Planner Robbins, there is a difference. They do only offer an 800 square foot, 1 unit property for short-term rental. So this idea that they do not know the difference, or there's some error in their business, this is their business listing short-term rentals, and they can't tell the difference of when they're offering up for short-term rental their entire property versus offering up one floor, is disingenuous. There's been no additional information that indicates that they are residents except for their own testimony, and that testimony is biased because they want to get this permit. Additionally, they were never present when staff went to the location. Why weren't they present? Because they didn't live there. All of the evidence that we have indicates that they were not residents. They did break the law when they listed the property when they knew they shouldn't have. So there's no reason for us to really believe that they're going to follow the laws and find any exceptions. So I would, if we were voting right now, I would vote to adopt staff's recommendation.
Thank you.
Do I allow to say anything?
Well, the public hearing is technically closed. Do you have any additional evidence or documents to put forward that you haven't put forward yet? But other comments, really, we've already had a chance for.
That includes council.
Sure, go ahead.
Just briefly, the downstairs unit, she testified that was something that was rented a long time ago. As far as that being their residence, where else would they live? How could she lie about that? That's where they live. That's where we told you we're happy to provide you with utility bills, ID cards, whatever evidence you want next week, in terms of establishing that that's their residence. At the same time, their mortgage and everything else would require it to cover homeowners and them living there. So we could provide that further documentation as well. To be honest, I think that what Mr. Rouse, the council, has indicated is that the totality of circumstances should be looked at. People should be given a chance to rent their place, and this is only for a very short period of time anyway. We're not talking about a long-term rental situation. I believe they're limited as to how long they can rent short-term rental. So that's all. Thank you.
Commissioner Seisline, any further deliberations or comments?
Yeah, I would just add to what Commissioner Patel was saying is that, I'm having a hard time kind of buying the naivete about, these are just mistakes we didn't know. I mean, we do know that when they applied in January for an application, from January to December, they continued to rent out their units, even though they didn't have a permit. And I believe Planner Robbins, you told me that there were 18 documented stays during July and December, correct?
That is correct. From July to December, there were 18 documented stays, and then there's the 2 more in January.
Right. So as they were trying to get this application, I'm really disturbed by the fact that they continued to violate the law, that they couldn't even wait until the application was approved. So, it's hard to believe that, if we were to grant them this permit, they would act above board when they haven't shown that they've been able to. So that's a real problem for me.
Agreed. So I have one comment and one I don't know, qualm or issue, which is one of the grounds that we have available to us for denial of this permit or confirmation of the denial by staff, by the zoning administrator, is the citation that has been issued, which Mr. Roush has explained to us is not fully ripened, if you will, or not completed yet in terms of any potential appeal process. So I just throw out as one option, and I should probably bounce it off Mr. Roush himself, whether an option exists that we could continue this particular hearing until such time as the citation issue has been fully, or at least, or terminated, fully adjudicated, so that all 3 potential bases could be considered in their entirety as any potential grounds for denial.
That's certainly an option that the commission could adopt, and I think that is in fact discussed in the agenda report, where it indicates that the item could be brought back to you once the assuming that there is an appeal to the citation in a timely way, that once that citation process has been completed, we would then return this matter to you with the outcome of that, and then the commission could look at everything that's been discussed so far, as well as the outcome of that citation. That would be an option. Clearly, during that period of time, there's no permit allowed, and so there would not be short-term rentals in that intervening period. It will be probably, I don't want to say weeks, I don't want to make it sound like it'll go on for months, but the appeal, getting somebody on board, it'll be 2 or 3 months before we would have a final resolution on the citation.
In the meantime, which the permit would stand denied by the zoning administrator.
There would be no permit for this property, so there could be no short-term rentals either listed or permitted until a final decision was made by this commission. Correct.
And so my other thoughts, and then I'll stop and let the round robin continue if we need to have it continue some more, is that I am, disturbed by the fact that this family that whose business it is to be in the short-term rental business essentially has kind of flouted our rules while purporting to make an application. As late as January of this year. It's not good. However, it seems to me that it might make the most sense for us to be able to consider all three bases all at the same time for any potential denial. Any other thoughts about that, anybody?
Why would we not just do the bases that we can right now, and then when the time comes to reconsider whether or not to do the third one, do it then? Because we're just going to have this entire hearing all over again. And if we just do it on the third one, then it's limited to that particular issue.
May I speak? Just one point is that I believe whatever decision the commission makes, there has to be a reason stated. There has to, okay, the appeal is upheld or the denial is upheld because blah, blah, blah. Otherwise,
let me cut you off. And I don't mean to cut you off, but I have an easy response to that. There are proposed findings in the staff report.
Okay, I just wanted to clarify that should happen, has to happen, I believe. The other option for the commission is
Chair Gooding, I think public hearing is closed.
It is, and we've had we've given some slack about interjecting a few points to make sure we have everything before us.
My last point.
Super short.
Is that the applicants can be put on some sort of probation, or there can be an inspection in a month, or you can ask for further items. And if it doesn't happen, then that no permit. Anyway, that's all I have to say. Thank you.
Thank you. So to Commissioner Patel's point, if we affirm the zoning administrator's denial at this point, there's an appeal process, and if they're appealing that while we're waiting for the citation process to also play out, it seems like we're starting one or two or three different engines going. I'm not sure.
It would seem to me if you deny the permit tonight based on other things other than the citation, there would be no reason to come back, because it would be denied, and that'd be kind of the end of the story.
But they have an appeal.
Certainly, right? Yeah,
Right.
And certainly, the applicants here, the appellants, they can appeal this decision to the city council. So, this is not necessarily the final step if they choose to pursue it further. So, I think you do have options here. You can make a decision either to approve or deny based on what you know, or if you want to continue the matter until we can get resolution of the citation, that's fine too. But I don't disagree with Vice Chair Patel that if we come back, we're probably going to have deja vu all over again for the hearing. So, that just goes with the territory, but that's the reality of the situation.
Okay, is it your advice, Mr. Roush, that at this point it is premature for the commission to base it, that if we affirm the denial of the zoning administrator, we could not at this moment use the citation as one of the findings?
I don't think that's the best course of action. I'm not saying that you couldn't do it, but I think there are other grounds if the commission is inclined to deny it, and use those grounds rather than the citation at this point, given the fact that the citation has not, the time to appeal has not completely run at this point.
Yeah, I agree. We have three grounds we can deny, and the one ground that's undisputed is that they had unhosted stays on the property. They don't deny that, so it's an undisputed fact, and solely, and we can deny just solely on that ground, and we can do that now. Waiting for the citation and whatnot, I think we're just delaying the inevitable. So we can make our decision now based upon one undisputed fact.
I agree. And I would say we would deny on all grounds and just adopt the recommendation as it is in all of the documents that were provided by Planner Robert Robbins.
All right. May I have a motion then from some commissioner?
I'm going to make a motion to adopt staff's recommendation for denying the permit in One second, I'm trying to find it now. And resolution 2021-STR-1.
I'll second.
And that includes adopting the findings proposed by staff, correct?
Yes.
That's correct.
We have a second. Voice vote, please.
Commissioner Funka,
Aye.
Commissioner Gomez. I'm sorry, I didn't hear that.
Aye. Sorry about that.
Commissioner Gooding,
Aye.
Commissioner Patel,
Aye.
Commissioner Sayason,
Aye.
Motion carries. The denial by the zoning administrator is affirmed by the commission. We read the appeal procedures. Anyone may appeal the action of the planning commission to the city council. Except where specified otherwise, appeals shall be filed with the city clerk not later than 15 calendar days following the planning commission's decision. Exceptions to the 15-day filing period include the following. Appeals shall be filed with the city clerk within 6 calendar days of the planning commission's action for use permits and variances, and 10 calendar days for tentative maps and advertising sign applications. An application form and fee is required to make a formal appeal. For additional information, please contact the city clerk at 415-508-2110. Thank you. Moving on then to study sessions and workshops.
Will there be a written decision? Can I just ask that sent to us?
There will be a written order of the commission.
Order? Okay.
That will be executed, but my statements about the appeal process stand.
Okay. All right. Thank you.
All right, staff, may we have the workshop, please?
Yes, thank you. Tonight's workshop is the third in a series leading up to the preparation of the draft housing element, which will be presented to the Planning Commission in the spring for your review and then recommendation to City Council. We can go to the agenda here for tonight. In tonight's workshop, we'll provide an update on Balance Brisbane. We'll also talk about the state's rules for how the housing element is to meet the regional housing needs allocation, or the RHNA. We'll also do a brief touch on housing constraints. Tonight's session is informational with the intent that it helps the commission in your consideration of potential housing sites, which is scheduled for your next meeting on February 24th. As was the case in the last couple workshops, there's no decision to be made by the commission tonight, but we welcome your questions. Associate Planner Robbins will be presenting results on Balance Brisbane. That online public input program on sites was open from early December through last Sunday, so approximately 2 months. He'll provide a quick look at the final results, and we'll follow that up with additional written reference materials for your February 24th meeting. So today's is pretty much a quick snapshot of that from him. And Senior Planner Ayers and I will then be presenting on the state's rules for meeting housing needs and housing constraints. With that, I'll turn it over to Associate Planner Robbins for an update on Balance Brisbane.
All right, thank you, Ken. Just give me a moment to find my notes. I have a lot of files open from the previous hearing item.
Can't imagine.
I thought I was prepared and had it open for you, but just give me one more moment here.
Through the chair, do you want to take maybe a 1 or 2 minute break and reconvene, just since we've been sitting here for over an hour at this point, and we do have some more to go this evening.
I would happen to love one. Let's come back.
Is that okay if we just put a 3-minute break?
Back in 3.
Okay, thanks.
Okay, are we all back? I guess not. All righty, everybody's screen is on. Are we all back?
I believe so.
Just say yes. Do we take a voice vote on that, Doug?
I can't take any more of those tonight. Jeremiah, go ahead, please.
All right. So I'm having a little issue with my notes, so bear with me, but I will go ahead and continue the presentation. I'm unable to open the version. It keeps reverting to something else. But so for Balance Brisbane, what I'm showing you here, We have the January snapshot, which we showed you in January, and the February snapshot. And this is, again, the percentage of sub areas identified for housing by submission. So we had 53 submissions as the time of we closed the Balance Brisbane, with over 400 webpage views. But of those 53 submissions, it's still 88% identified Baylands as a site suitable for housing, 62% for Guadalupe Hills, et cetera. You can see the numbers are pretty similar between the January snapshot of around 34 units and the February snapshot here, which has pretty similar numbers. So this kind of appears to show that most residents that submitted a simulation think housing should be spread out. But if we look at the next slide here, where you see the actual housing unit allocation, now these are averages, but you can see Baylands is by and far the largest one. The average was 1,800 units. Part of that is because the choice was between you can select 0 units, 1,800 units, or 2,200 units because of measure JJ. But again, looking at the average number of housing units submitted, you can see the second highest was South Bayshore Boulevard. It was less than 250 units. Guadalupe Hills and Parkside, just barely over 100. So we're not seeing high quantities of housing units allocated to the other sub areas. And that potentially poses a challenge under the state mandate for our RHNA allocation. We need 1,906 units with a buffer. And when you're trying to look at site selection as it relates to how many affordable units can be accommodated per site, how you determine the size of the parcel for that, and other housing constraints, there are potential issues, and it's very important how we determine site selection going forward. Do you have any questions at the time? And I have a map of all the sites here in case you had any questions for these sites here.
I have a question. So you said that the preferences that you've obtained so far pose problems, right? Or so just the allocations.
I wouldn't say it poses problems. I'm just saying what was submitted, the numbers are pretty low, excluding the Baylands, obviously, when we're kind of trying to find our site selections to accommodate housing units, and not only housing units, but affordable housing units.
Yeah. Okay. I think I would be interested also to see a proposal from a sort of a qualified person such as yourselves, like what would be more balanced, for example, just something to react to. Just curious, I don't know. And maybe that will come up in the future. Like what would represent a more balanced thing that would allow us to distribute affordable housing in a way that makes sense,
That's a good question, and it's actually one that we'll be exploring in detail in the meeting in a couple weeks. We'll be looking at the various sites and talking a bit about constraints on each and the numbers, and we can talk about how those stack up. And really the idea of that is to get your thoughts as a commission on these various sites. But
okay, and then if I may, I don't want to drag this out, but I have a follow-up question. Is there a way that there could be another iteration of the website that builds in more constraints so that people, right now it just seemed like, well, you could do this. You could just put everything on the Baylands, and people certainly had that option. But I wonder if it could be constrained to say, that's not really ideal. And then just do another iteration of it. But I don't know. I mean, you only had 53 participants out of all the people in Brisbane, so I don't know how much interest there would be in even doing another one.
Right. Our hope would be that we get also some participation at the Planning Commission Live, where you might get people tuning in to the meeting and providing feedback. And as we give you written materials in advance of this next meeting, you'll see a bit more detail as well in terms of comments and such. One real concern is just our time frame for moving this forward to the city council to get it onto the state in time. So that's a real concern.
Mhm.
So Chair Gooding, we have kind of built-in breaks for public comment if you wish, if you want to open it up.
Okay, sure.
You want to do like 30 seconds or so?
Sure. Any public comments within 30 seconds, please, on this segment so far?
We do have a hand raised. It's Barbara.
Hey, so I kind of object to the language that this survey identified the Baylands as a area suitable for housing. I don't think that was necessarily a correct conclusion drawn from people's answers. I mean, I played around with that thing for like an hour. I was probably your most dedicated poll taker. Just because I wanted to see if I could allocate the required number of units without using the Baylands. And I was able to do it. But like I said, it took me an hour and a lot of tinkering. And I think what you're actually seeing here is that people see a big empty bucket. They got a lot of things that have to go in a bucket, and they put all the things in the big empty bucket. I mean, it's just sort of like a square peg, square hole kind of thing. It's really hard to complete this survey without dumping a lot of housing on the Baylands. I don't know how you make this fairer. I did submit a comment to the people who did this, that they need to include a column for density, because that's how we determine low-income housing, is by density. That's kind of the state's benchmark, and that doesn't even figure into this. So it's kind of missing the point in some ways. And I think that it's leading to some kind of weird conclusions the way it's set up. But I do encourage people to do it. It's just, it's just weird.
Yeah, thank you. Any other public comments?
There are none.
All right. Next phase then, please.
Thanks, Jeremiah and the commission. Next slide, complying with our RHNA. The next portion of tonight's workshop is focused on how we meet the RHNA. That is, what are the state's requirements to claim housing units and the housing element. This is a fairly technical part of the housing element law, and we tried to boil this down to what are the big takeaways for Brisbane, how it applies to us. Our presentation is centered on three main questions. What are the state's requirements to meet the RHNA? What if we don't rezone by the state's deadline? What if development doesn't match projections during the housing element period? And next slide. On that first question of what are the state's requirements, we'll set the stage in terms of the numbers. As you may recall, the RHNA is that number of housing units that we have to provide zoning for in this housing element cycle. It's assigned by the state through ABAG. Then we'll talk about the state's criteria for how to claim sites to meet the RHNA. That's for both sites with existing zoning and sites to be rezoned. Then for the sites to be rezoned, what are the requirements by income category? And next slide, please. So first, on the state's requirement, what are the numbers? As we've talked about in our previous sessions, Brisbane's allocation is high in this cycle, with a need to provide zoning for nearly 1,600 housing units. Assuming a buffer of 20%, that brings it to just over 1,900 units, with 600 in the low to very low income categories. And next slide, please. On the 20% buffer, the state has no net loss rule. This is new, that it's effective for this cycle. That means that if a projected housing site gets approved at a lower density or at fewer inclusionary housing units than what it was planned for, we still need to maintain zoning to meet the RHNA. The state's recommended a 15 to 30% buffer to address this provision. Ultimately, as we look at sites to include in the housing element, we want to look not just at meeting the minimums, but what are the best sites to address housing needs, and at the same time, contribute to the community on a holistic basis. Next slide, please. We clearly have a challenge that we need to solve through our housing site selection. Our last cycle's RHNA was significantly lower, and we rezoned enough units to meet it, with 389 total, and 234 of those were credited in the lower income categories. Given this cycle's RHNA, the total shortfall, including the buffer, is over 1,500 and approximately 360 in the lower income categories. We'll refine these numbers as we look closer at what was developed and what would go off the list of available sites based on development that's happened, as well as some incremental increases that we will likely be able to claim for ADU development trends. But this provides a pretty close snapshot of what our challenge is in terms of numbers. And next slide, please.
So can I ask, can you explain the math there a little bit? I just want to make sure I'm catching up.
Sure.
So 1571 is that's the minimum we'd have to allocate or zone for.
Yeah, and again, these are approximate numbers. We'll refine those when we come back to you. But so that first row there of from 2015 to 2022 housing unit potential units, housing element potential units, that's straight out of the housing element for the current cycle that we're in. So that's what we zone for, either through the Parkside plan or was already available as infill sites. So it provides you essentially a pretty close estimate to where we are. We've had production of about 50 units over the cycle so far, so we'd reduce that by about 50. And what's that RHNA plus the buffer? Well, it's in the total category, it's 1906. So, just rough numbers, we're looking at a shortfall of 1,500 that are not currently zoned to
provided for. Okay.
For housing.
All right, thank you.
You're welcome. Okay. So how do we meet the challenge? The first part is to look at existing zoned housing capacity, especially in the low to very low income categories. As with the last cycle, the state still allows us to claim sites that are zoned by right at the default density, which we have for the Parkside area, but that still leaves us short by 360 units, as you saw on that last slide, in those categories. There are few, if any, other sites anticipated. There may be one or two small infill sites, and we'll be confirming the timing of when those are projected to be done. But so there might be a few units to claim aside from Parkside and the low to very low income categories. So we have a shortfall for these categories, and we must rezone for that. Next slide, please. On the moderate income and above moderate, or market rate is another term for that, the state allows cities to project the number of units a site will realistically develop based on analysis of existing development standards like height, setback, density, ranges, of course, also site access and utilities, and trends for similar sites, similar in the same zone. This method will apply to infill sites in central Brisbane and Southwest Bayshore, just like we did in the last housing element. And they're not, those that's because they're not zoned to minimum densities there. Staff will be updating that capacity number for the commission's review. But as we just mentioned, based on the last cycle, it'd be less than 150 units likely, and has shrunk some due to development that's already happened. So again, we have a shortfall in this category, significant shortfall, and must rezone. Okay, next slide, please. There are essentially two types of zoning to meet the shortfall. The first would be to upzone lower density residential to higher densities and assign minimum density standards. One example of a possibility that was put forward through Balancing Act is that lower Thomas Hill area within the Brisbane acres. The second rezoning type would be to rezone sites that are not currently zoned for residential uses to allow residential going forward. Several potential areas were included in Balance Brisbane, such as the Baylands, Levinson site, an extension of the Parkside plan, Southeast Bayshore, others. Okay, next slide. So again, this map, you've seen it a few times now, shows the different areas that were included in Balance Brisbane, some of which were suggested for rezoning or upzoning. The central Brisbane and Southwest Bayshore areas, these are labeled 8, 9, and 10, and 11 on this slide, 8, 9, and 11. Were also included for completeness regarding infill capacity, but not necessarily for upzoning. We can come back to that as needed, and we'll dive deeper into the specific sites, as I mentioned, in our next meeting. And next slide, please. And this is my last slide, and then I'll turn it over to Julia to close us out. So we'll have a shortfall in sites zoned for housing across all the income categories, and we can upzone sites and rezone new sites to meet that challenge. For sites that are not yet zoned for housing, but will be, the state has specific criteria for the rezoning. It must be at a minimum density of 20 units per acre on sites that are large enough to accommodate at least 16 units. The zoning has to be by right. So a use permit or similar discretionary permit could not be required. There's also a limitation on the number of mixed use sites. These criteria are, if these criteria are met, 100% of that minimum density can count toward the lower income RHNA. To meet the moderate and above moderate units, credit towards the RHNA would be based on minimum zone density. Also, we can use surplus lower income sites. So using the Baylands as an example, assuming we zone the entire area at either the 1,800 units or 2,200 units, consistent with Measure JJ, a portion would be counted to the lower income as needed, and the rest could count toward moderate and above moderate income. As an aside, we want to clarify an error that we had in the staff memo regarding the criteria for rezone sites, and that's related to a 20% affordability requirement. So contrary to the statement in staff's report, there's no requirement for the city to impose a minimum affordable requirement of 20% on rezone sites. We received updated guidance that the rezoning regulations must allow development proposals that voluntarily include at least 20% of affordable housing for lower income households. So that would be by right. This provision actually seems a bit redundant since the zoning would need to be by right anyway to claim these kind of sites. Nor would the city reject voluntary inclusionary housing over what we require as a minimum. And Julia will talk more on the inclusionary housing in a moment. Also, as I just mentioned, the city can claim lower income RHNA credit on rezone sites at 100% of the minimum density site yield. And finally, on this topic regarding the zoning deadline, we have a clarification. The state's deadline is 3 years from the statutory deadline of the housing element, which is next January, just short of a year from now. So that would be 3 years would put us out to January of 2026. However, that's contingent on the state certifying our housing element within 120 days of that housing element due date. Otherwise, the state moves that rezoning due date to within a year, which puts us at a due date for rezoning of January of 2024. Staff has been informed that for other regions whose housing element deadlines have already passed, the state is rarely certifying them on time. The rate that we're hearing is that it's less than 5% of jurisdictions, and probably closer to about 2 or 3%, that are actually getting certified elements from HCD on time. So given these timing constraints, we need to assume that rezoning needs to be done by January of 2024. So we just wanted to clarify that and give you a fuller picture of those timeframes. And with that, I'll turn it over to Julia to talk about implications of not rezoning.
Great, thanks, Ken. So if we don't accomplish our rezoning for our RHNA shortfall by the deadlines that Ken just mentioned, whichever applies, a couple things happen. One, a developer could go ahead and propose a development project on a site we identified for rezoning, regardless of whether that zoning had been adopted. And the city would have very limited ability to either deny the project or impose any conditions that would reduce its density, assuming the project complied with the minimum density set forth in that program and any other objective standards that would have applied as well. There is an exception if there would be a health and safety impact that could not be mitigated. The city could potentially deny or reduce the density of the project. But that's a very limited circumstance. The other domino effect that would happen is our housing element could be decertified because it would not be in compliance with housing element law. This would invite enforcement actions by the State Housing and Community Development Department, which under recent changes to state law has now actual capability to enforce housing element law. They can also refer non-compliant cities to the state attorney general for action for non-compliance with any provision of housing element law, should they so choose. Next slide, please. Okay, we also have a situation where oftentimes, what we may project in the housing element and get credit for via their methodology may not exactly match with developments that are actually delivered by the market and built and approved. So like Ken was explaining, the city is allowed to take full credit in our RHNA for lower income RHNA if we identify sites that meet the minimum default density of at least 20 dwelling units per acre. For example, the Parkside plan sites, both the PAOZ1 and PAOZ2 have minimum densities at or exceeding 20 dwelling units per acre. So in the housing element, we could claim 240 units as meeting our lower income RHNA requirement, which, as you may recall, is about 600 units with our buffer. However, if a market rate developer comes in and develops those sites, a market rate project would only deliver whatever our inclusionary housing ordinance requires to be affordable, which for 240 unit project would be 36 units to low and very low income households if it's a rental project, and as low as 12 units if it's a for sale project to low income households. So that's just looking at that one potential sub area as an example of that mismatch. So that's why why HCD recommends having a buffer of up to 30% when you're zoning, when a city has to zone for RHNA shortfall or accommodate in their existing zoning. That buffer ensures that in that situation where we've claimed 100% credit, we're only getting, 36 units instead of 240, we have other sites in the arsenal that can then keep us in compliance so that we're not losing any zoning capacity when projects actually do come forward and are approved. And next slide, please. Oh, any questions or discussion on those components?
I had a question on this last one. I think I understand what you're saying. So you zone something to allow a high density, affordable, but a developer might say, but that does not preclude a developer from developing at lower density with less affordable housing. Is that right?
Not exactly. Oh, go on.
I was just wondering if we can actually say you cannot build at low density here. Do we have a way to zone like that?
Right. So yes. So what I was saying was, so in order to take credit for a site to count towards our lower income RHNA, we have to have a minimum density imposed, which we do for right now. The Parkside overlay zones are the only zoning districts that have minimum densities. That literally means if a development comes in, it has to have at least development at 20 dwelling units per acre.
I see.
So
Okay.
that is already imposed in the PAOZ1. Our other districts, like in central Brisbane, the R1, R2, R3, have maximum densities, not minimums.
Oh, interesting. Okay. Fine.
So minimum densities are a tool to have more certainty, of course. Like if I think Ken, stop me if I'm going too far, but I think we're going to be talking about that a little bit more at our next workshop on not only specific sites, but also policies and programs, is whether the city is interested in adopting more minimum densities in other zoning districts to make sure that we don't have a situation where there's a huge disconnect between what's developed in terms of density. But what I was talking about was not so much the densities that we're claiming, but the actual income categories that housing is serving. So what that part, do you want to go back to that slide, Jeremiah? Yeah. So for us to claim, again, this site's going to develop, it's at this minimum density, so we know it's going to produce a minimum of 240 units. We are saying in the housing element, because it's at this 20 dwelling units per acre minimum density, the state has determined that density is adequate to accommodate the development of lower income housing. Because the state has determined that, they allow us to say, okay, here's the site, it meets that minimum density, it's going to develop at that minimum density, and we are projecting 100% of those 240 units will be affordable to lower income households. It knocks off 240 units from our 600 unit RHNA for lower income households. So it's not the disconnect is not between the number of units, it's between the affordability of the units that are actually built in a situation where, again, most residential developments, unless you have a zoning ordinance that requires a minimum affordability requirement, which is also possible, and we can also discuss that more when we talk about our site selection and policies and programs. But without that, you cannot guarantee that the development that's built is going to be affordable to anyone other than above market rate buyers without our inclusionary requirement, which, as you can see, is a very 10 to 20% of the development versus 100. That's quite a discrepancy. Is that more clear?
Yeah, that makes sense. It sounds like programs and policies might be where you can address some of that. But okay.
Yeah, we can have more certainty. There are tools to have more certainty we could consider in terms of affordability.
Thank you.
Sandeep?
My question is kind of in the same line, is how much do we have to moderate the tension between having something that's going to be zoned at a minimum density and it not being marketable to build at that density, so it never gets built? Does that make sense?
Yes.
It does. Question.
So like, are we responsible for that? I mean, we could say like, hey, we'll have minimum density of 1,500 units on this particular, piece of property. But if it doesn't make sense to build that many units commercially for someone and it never gets built, I mean, do we still get credit for it?
It's a great question, and it actually is addressed in the housing element law, and I'd have to check the numbers on this, and we can come back with that answer for you. But essentially, if you go over a certain density, the state wants you to actually demonstrate that these would be marketable. And also, if they're looking for a sweet spot, right-sized on the sites as well, between 0.5 acre and 10 acres. So there are, we talk in terms more of minimum densities. Since really in Brisbane, we haven't wanted to entertain really high densities and in the past, but we can bring that kind of upper limit to you to let you know. But yeah, we can't just pick a 1 acre site and say, well, we're going to put all those housing units on that site and have a tower and call it good, unless we can prove that it's marketable. But I'd highly doubt it.
So what I was going to say is that our primary obligation as a commission and a council and a city is to create a housing plan that would allow for construction that meets our arena allocation. Right? Am I right so far?
Yep.
Okay. And then at what point does somebody measure us or sort of check us or vet us as to how marketable the zoning plan is to the marketplace? And how in the world do they do that?
So once it goes through city council, it will be submitted over to HCD, the state, for review. And they're going to look at what we've laid out as essentially evidence in the housing element that these are actually, that they fit the state's criteria in terms of those ranges of site sizes and densities. We're not using that kind of formula, that we've done adequate analysis to actually demonstrate that yes, it passes the test essentially of HCD, and that's we will expect to go through. What I'm hearing is most cities are going through a few rounds with HCD and every city has their own nuances and differences, but yeah, they put a critical eye to what we send them to make sure from an objective standpoint that yes, it meets the requirements, and it's going to be something that's reasonable.
And if I could, Ken, I think housing law is very malleable and it changes over time. And the rules that govern housing elements 2 or 3 cycles ago, well, it was really kind of a paper tiger, was a theoretical exercise, and a lot of people sort of gamed the system and identified sites that were very unbuildable and as being kind of credited for meeting RHNA and whatnot. And yeah, it's changed. And this whole idea about making sites more feasible and more realistic and accountable. And I wouldn't be surprised if future housing element cycles, that the idea of production, because right now the city is not really on the hook for production, or we're not liable if production categories, our numbers aren't met. But I wouldn't be surprised if the current trend continues, there'll be more accountability on the part of the city if production doesn't achieve those numbers. But housing law will change over time, and how that will shape the next housing element, I wouldn't want to speculate at this point, but that certainly is the trend of the future.
It seems to me like, well, this is more rhetorical, but RHNA the allocation of RHNA numbers should have to pass some sort of reality-based test about how reasonable those were to impose given the state of the marketplace. But that's just rhetorical. I don't expect any of you to have the answer to that. So anyway, any next phase, or are we done for now?
Did we? There's like one more slide. Are we gonna?
Or a
Jeremiah,
couple.
is there a comment? Okay.
Yeah, if there's anybody out there.
So Chair, if you want to invite questions from the public or comments.
Yeah, why don't we start a timer for 30 seconds, see if anybody pops their hand up.
Barbara Ebel has raised her hand.
Hey, Barbara, go. Can you hear us?
Sorry, talking while muted. If it's with the chair's permission, if it doesn't take staff too far off to the side, I was wondering what the housing unit prices are for these various brackets. You know, low income, moderate income. What numbers are attached to that? Just for my own sort of informational, educational purposes.
Yeah, so this was presented in actually the December workshop had a table, and I repeated part of that in the last workshop. And I am trying to remember, for a 4-unit household, I think the 4-person household, the very low income was somewhere close to 90,000 per year. And I am forgetting on the high income side, but it's
with December I can go find that.
okay.
Thanks. I didn't remember it.
Okay. Any other public comments on the screen, Jeremiah?
There are none.
Okay, thank you.
We did have a next steps
Well, we
slide
talked
after
about
this. Oh, right.
Okay.
I'm jumping
We
ahead.
do.
Sorry. Later.
I know. Don't worry. I'll talk very briefly on this. So the housing element has to evaluate and remove, where feasible, constraints to housing development. So that's both governmental constraints that are arguably within our control. Of course, there's a whole slew of constraints that are not in our control. So we listed in the staff memo a few of the most obvious and significant constraints. Again, many of which we can do some things about, some of which are just totally out of our hands. And I will end my review there, Ken.
Okay.
Again, if there's questions, and then we can open it up if there's any comments or questions from the public.
Okay.
I should say, I mean, as we said in the staff report, we'll talk about site constraints that apply to specific sites on the 24th.
So why don't I open it up to commissioners if they have any questions, and then if we have any while we're talking, we can then see if any public pops up.
Sure.
Any commissioners have any comments or questions?
So is staff expecting us to come up with a proposal, or will options be given to us to decide?
For identifying sites for our RHNA shortfall?
Yes, just everything, because I feel like, I'm having a difficult time grasping what it is that is expected of us at
that
this.
You'll be doing, yeah.
Mhm.
Right. So we will present, and to be honest, I don't have it all worked out as to how we'll present this to you, but I'm envisioning some sort of table kind of format that lists out the different kind of larger sites that are within Balance Brisbane. And I haven't heard any other sites mentioned besides those, and I think those are really the key ones under consideration. And so put together some information on constraints, also kind of summarize what the different densities would be under each, and just kind of get your thoughts on based on the constraints that we talk about in that next meeting, as well as those densities, how you might like to see the housing element sites be selected, whether it's, 3 different areas or 2 different areas or 4 different areas, and you could adjust the densities. So I think it'll probably start at, what are the key sites, to narrow down those, and then talk about what are the densities that are preferred at those sites, and see how the numbers play out. And it may be something that carries into March as well. I anticipate it's going to be a fairly involved discussion with the Planning Commission. Probably less us talking and more you all talking, but we will present and frame it up for you.
So
Okay, thank you.
do I have it right then that the sort of macro view of the process is that staff's opinion is that compliance, in order to comply with our reallocations, we're going to have to take some serious looks at rezoning, and that the commission's job is to work with staff to get a draft proposal about the rezoning for the council to consider?
Right. Essentially, you're not getting into the details of, like we have, for instance, Parkside Plan was a rezoning, and that started as a program in the last housing element that said, we're going to use these sites and a minimum density for those sites will be such and such. And then the details of that, and it might have even had a maximum included in there, I don't recall. But then the details of that rezoning were worked over a 2-year period in which there was quite a bit of public input and deliberations on it. So it's really a programmatic kind of designation that will go with the housing element to City Council.
Is there any, do you have to build in some sort of feasibility into this? Because like you said, there's a lot of cities that you rezone, but nothing happens. And they could have probably told you when they rezoned it, never going to happen. So when we rezoned, do you have like an idea that, well, if we rezone it like this, we can maybe tilt the table a little bit. Maybe that's where the programs and policies come from. So that, yeah, this is actually reasonably likely to happen, because just rezoning by itself doesn't do much good necessarily, right?
Right, exactly right. And that is something that we do need to show in the housing element. And it's a reason, as a prime example, I guess, is Brisbane Acres has come up in the last meeting as a concern. There are certain areas of Brisbane Acres, and there's a lot of acres in that sub area that are completely vacant, but by dint of their lack of access, lack of utilities,
size,
habitat issues, size, we're not really putting forward as being under consideration for upzoning, although they could theoretically be developed with housing. So we did look at that section of the lower acres that is close to Thomas Avenue and San Bruno Avenue, and has close by utilities and much easier access. So that does play a part. We don't want to put forward something to the state that's just not reasonably feasible.
Okay. During this time, have we gotten any public pop-ups?
We did not.
Okay. All righty. Anything remaining in the workshop, or we reached the close?
I think just next steps. So we have our meeting that I mentioned coming up in 2 weeks on the 24th, where we'll talk about inventory discussion. We may get a little bit into draft goals, policies, and programs, it's probably more related to those sites that you're looking at. And on the 10th, March 10th, we'll get more into goals, policies, programs. If there's carryover on sites inventory to March 10th, we could do that there as well. We're planning by mid-April to have a draft element actually put together for a 30-day comment period. And then in May, actually have the public hearings at the Planning Commission to put that over to the council in June timeframe.
Okay.
Sorry, through the chair, we got a comment, I think, right on the, as you were saying that we were closing the comment period.
Okay.
Can we respond to
Sure.
the comments from Barbara Ebel asking about how housing costs are calculated for each category? So Ken, correct me if I'm wrong, but I think the assumption is still a 30% of your income is the maximum that you should spend on housing for any income level. Is that still the assumption?
That is correct. And it's established for the countywide. Countywide is assigned those numbers. So
so Barbara, for any, whatever the annual income is, if you're spending more than 30% of your income on housing, it's considered not meeting the definition of affordable housing. I think the root of that is actually in the state code. But yeah, 30% is the factor.
All right. Thank you, everybody. Very helpful. Look forward to moving this forward. That completes the workshop, right?
Correct. Yes. Okay. Thank you.
And I've been asked to flip the agenda slightly, and we're going to move on to any items initiated by any commissioners at this time. And I understand we have at least one.
Is this my moment to say some fond words? Okay. Late in the evening. Yeah, well, I guess to the community and to the commission and to staff and to everybody, it's been an absolute pleasure to be serving since I believe it was springtime 2018. I have a lot going on in my respective world right now. I sent a letter to Director Sweeky, and I'm pretty sure that's been circulated. So I'm not pursuing another term as commissioner. However, I will stay very much aware. Not exactly sure on the timing, but I'm willing to support until we have. You guys got to let me know. It's been a absolutely wonderful experience. A lot of learning, a lot of growth, a lot of deeper appreciation for all the mechanics that go into what is a very in-depth topic of planning and policy and zoning and so forth. And I have the highest level of respect for both the commission and city staff for all the work that goes into this. So it's a little weird saying this by camera, right? We haven't been in person in 2 years. This is like half the experience has been virtual, right? But yeah, here we are. So not goodbye, but I guess farewell, right? That's what we say.
Well, thank you, Napolo. I want to, at least for my own sake, thank you very, very much for your service and for your time. It's been a real pleasure for me to have been on this commission and see how well we can work together and work things out and have really, really good discussions at a really good level. And you've been an integral part of that, and I want to thank you very, very much.
You're welcome, and thank you. Like right back at you, Commissioner Gooding, Chairperson Gooding.
And on the part of staff, we wanted to again send our appreciation and our thanks for your community service and thoughtfulness and dedication to which you kind of applied yourself to the work of the commission, which isn't always as glamorous and as exciting as you might have thought when you signed up for it. But we do appreciate all your efforts, and we'll miss working with you.
For sure.
Thanks, John.
I'll echo that.
Yeah, here.
I know I'll still see you at the farmer's market, right?
You'll probably run into me in various places. I get around town. I get
All
around
town.
locality. Yeah.
Right. Any other items initiated by the commission then?
Well, Commissioner Gomez isn't the only commissioner who had planning commission service news. I don't know if Commissioner Patel, if you wanted to let your peers know.
Oh, I reapplied and was luckily appointed once again for another 4-year term. So you guys get me for another 4 years.
Yay.
Very good.
Congrats.
What, John or Julie or anybody, when will we know of our next appointee, and when is an appropriate time for me to pass a gavel?
Well, I was kind of, if we want to jump onto staff initiated items, that was the first item of business, is the same meeting that Commissioner Patel was reappointed. The council did appoint a new commissioner, Commissioner Alex Lau, and he will actually be ready and jumping in the meeting of the 24th. So he'll be at your next meeting. You have a new peer, and welcome
I see
aboard.
he's in the audience tonight.
Oh, okay. Well,
yeah, that's fine.
So yeah, we're moving right ahead, and we look forward to his service as well.
So that would be the appropriate time then to appoint a new chair, I assume.
We'll agendize that. I believe it's first meeting in February, I believe, by your rules. So we'll put that on as an agenda item.
First in February or first in March?
We'll double check.
First in February, but we didn't have any new.
I blew right past that one.
Yeah. I believe we agendized it for the first meeting in March.
Yeah, sounds good. Okay.
And one other item, just for the reminder of the Planning Commissioners Academy. I don't know if anybody's expressed interest. Again, I know some of you have been to it in the past, and we really do encourage anybody who can attend to attend. It's a good way to kind of get exposed to a lot of planning information in a short period of time, and meet some of your peers, other jurisdictions. And so if you can, please consider it and get a hold of staff, and we can make those arrangements for you.
That's the 15, 16, 17 of March, I believe. Is that?
I believe it was mid-March.
Yeah.
And they're all day events or evening events?
It's a multiple day conference. It's drivable, but you could also stay out there. I mean, at this point, they were doing it live too. It's not a remote, it's an actual live conference in the East Bay.
So it's not Zoom, it's live.
Correct.
Okay. All right. Okay. Any other items initiated by anybody?
That's all I had.
All right. Okay. Thank you very much for your workshop again. Very helpful. And I think we stand adjourned until the meeting of the 24th. Thank you all.
Bye, everyone. Bye, Napoleon.
Bye,
Good night.
Napoleon.
Bye, guys.
Bye, Napoleon.
Take care. Yep.
Thank
Bye-bye.
you.
See you soon,
Bye.
Alex.
Take
Thank
care.
Bye.
You. Bye.